Hi guys, and welcome to the fifth lecture on Indian Contracts Act. So today in this lecture we'll discuss about the a very important question which is a part of various multiple examination. That it's a descriptive question, and it has the inclusion of various sections of Indian Contracts Act. The discussion is on a question which comes that how can a party discharge the contract, like in all the ways how you can discharge your contractual obligations once you have entered into an agreement, into a contract which is a legally binding agreement. What are the various ways you can discharge your obligations? So here we will see in detail that what are the possible ways with which you can discharge your contractual obligations. So the first and the very basic thing is how you can discharge is by novation. So if you see section 62 to 64 of the Indian Contract Act, section 62 talks about the principle of novation, rescission and alteration of an agreement. Novation specifically is the process of making a new contract. An existing contract, if it sees any change in the parties, if some party delegates its contractual obligation to another parties and absolves its contractual responsibilities, then the previous contract gets novated. Rescission is the process when you stop working on a contract, you decide to terminate that contract. So novation is a prime way with which an existing contract is discharged and the party transfers its obligations, right or duties to another party to execute it. So apart from novation, the next thing is section 63 of the act, which says about accord or satisfaction. If some contracting party it's unable to do his job completely or in a matter which is acceptable to the customer or the owner or the promisee of that contract, in that case they can discuss on the unsatisfactory result, and they decide mutually, they can decide to sign an accord for the stoppage of the scope of work from that party. They can negotiate on the amount to be paid because the work is not totally executed as per the contract. So they can sign an accord, they can discuss on the negotiated amount, and such amount is called satisfaction. So signing an accord, agreeing on a satisfaction and closing the contract is another way with which a party can wind up its contractual obligations, and it is mentioned in section 63 of the Contract Act. Third way is through any waiver. They can discuss on any waiver and they can make the scope changes. Now fourth way to discharge is by performance. The party can perform its contractual obligation, which is the most standard or ideal or intended way, and they can complete the obligations and they can close the contract or discharge their responsibilities. Now for the promise by the performance also, which is mentioned in section 37 of the agreement. Section 37 says that the obligations must be performed in order to discharge your contractual responsibilities. The further elaboration is made in section 40 to 45 of the Act, where 40 says about the authorized person, that the the promisor can authorize somebody to execute the contractual liabilities. And at the same time, there section 42 to 45 talks about the joint liability, where two or more promisors are there, their joint rights and all. So if somebody asks you by performance how can you discharge the contract, what are the references from the Contract Act, you can say section 37, section 42, 45. Now the next way is by impossibility of performance, which is doctrine of frustration, where you cannot do anything, you have to discharge it. Here the prime thing comes in the force majeure, which is a part of various standard or international forms of contract. A situation where none of the party, the stoppage or the situation is not in control of any of the parties, and they can't do anything except to wait, like any act of God, any international ban, restriction, epidemic, pandemic, anything. There's a long list of items which are beyond the limit and control of both the parties, the contractor and the owner. In such case, they can't do anything, they have to wait for some time, and nobody will be required to compensate anybody because it's beyond the control of both the parties. And once such timeline is as specified in the contract passes by, they can terminate the contract. So this becomes a situation of frustration. That is another way to wind up your contractual obligations when you can't do anything. Apart from that, there are the impossibility of the performance, which we have seen in Contracts Act at various points, like Section 56, related to void agreement, that any agreement based on any impossible act which cannot be done becomes void, and this is again based on the impossibility of the performance. Section 36, Section 32, impossibility of the contract becomes void because they were based on either an impossible contingent on some uh, impossible event, or any uncertain event which becomes impossible. Then the third way to discharge your obligations is by death. If somebody dies, then his representatives, as mentioned in Section 37 of the Act, or any successors, they have to take care of the things, but the person is absolved from his liabilities once he is dead. Then by operation of law, as we discuss, like in various cases, if any, in the force majeure cases which we just discussed, various heads with the change in law and any ban as per the law, war, restriction, sabotage, etc., that becomes the operation of law. The next category is by unauthorized act. Some of the party does any act which is not authorized as per law, and they are banned, or there are any other restriction for them to do contracting. They are restricted by law to go into a contract or carry on with the contract, or barred from sub country. In all such cases, the contractual liabilities are discharged. And then the last one is by breach of contract. If any party makes a breach of contract, they discharge with the contractual responsibilities, but at the same time they need to pay for the damages. So this stipulation in Contract Act, it is mentioned in, first of all, Article 39, because Article 39 says that a party, if it breaches, it is called a breach of a party as per Section 39, that if it refuses to perform the promise in a whole manner, at a whole, not partial. It says I can't do the promise, I can't fulfill the promise. As per Section 39, it will be counted as a breach of the contract. So this is another way. But in such case, the party will be subject to the effects of such breach, which are mentioned in Section 73 to 75 of the Act. Also, there are some instances, there are some situations which are mentioned from Section 46 to 48 related to breach. 46 to 48 sections of the Contract Act says that if party executes the job, but if he could not respect the timing and the place requirement mentioned in the contract, in such case the agreement will not be construed as done or completed, and his obligations will not be considered as discharged. So in such case also, which is mentioned in Section 46 to 48, the party is required to execute the job again, and if he denies to do so, he is in the party is in the breach of the contract. So based on 39, 46 to 48, the breach comes, which is another way to discharge the contract, and the consequences are mentioned in Section 73 to 75. We'll quickly see those also, because that is important to know the consequences when a party breaches and it discharges its liabilities. In such case, it need to pay compensation for the damages. Section 73 says about the compensation of the loss or damage due to breach of the contract which one party suffers because of the breach from the other party. In such case, the other party which is breaching the promise, it is required to compensate the suffering party for the loss or damage that suffering party has incurred because of the breach from the party who is breaching. But in such case, Section 73 says that remote or indirect losses are excluded from such claims. Section 74 talks about the penalty. It is a bit different from Section 73, because Section 73 says about the absolute loss. Whatever is done, if it is within the limits of the contract, it needs to be compensated. While Section 74 talks about the penalty, which is the compensation for breach of the contract. This clause, this section remains silent about the loss or damage or proving that, means it says such penalty is liquidated or fixed, and the party who's suffering, it's not required to prove the actual damage it has incurred. So it means that whenever there is a breach of the contract, there is a straight away penalty as per Section 74, and the party who's breaching, he is required to pay that penalty irrespective of the incurring of any loss or damage by the other party or suffering party. While 73 says that it is a compensation based on the loss or damage which it has incurred. Section 75 says the situation where a party resigns the contract because the other party has not fulfilled his promise. So the party who's resigning a contract, it is still entitled for a compensation for the losses or damages it has occurred because of the breach of the other party. So it says that standard clause in our all agreements where a party has the liquidity damages realized, which are mentioned in section 74, and once those losses are completed and still the party who is breaching the contract could not materialize the promise or could not discharge his obligations, the contract is terminated. So that situation comes that the rescission, it does not absolve the party who's at fault to wash away its hands with just the rescission or termination of the agreement. It is required to pay for the damages which the party who is suffering because of his breach is incurring. So these are the consequences. So typically we have seen in this question that how the we can discharge the contract. We have seen that section 62 by novation, section 63 by accord and satisfaction, by waiver, by performance, which is sections 37, 40 to 45, by impossibility of performance, which is again from the reference of force majeure, and the reference from section 32, 36, 24 to 30 and 56, because voidability is also a situation where you can't execute. By death, mentioned in section 37, by operation of law, which is a force majeure situation we discussed, by unauthorized act, which is a disqualification from the contracting, and by breach of the contract, which is mentioned in section 37. The situation, the possible situation are mentioned in section 46 to 48 based on the default of not respecting the time and place of the obligations, and the consequences of such breach are mentioned in section 73 to 75. So with this, I'm closing this lecture. Hope you have understood the crux, because this question is very important. It covers all the important sections of essentials of the contract. It touches sections in 30s, in 50s, in 70s, and it covers to an extent the crux of the contract act, essential of contract act. Hope you have understood. Stay tuned for the future lectures. Thank you.